Day marks this historic day at the U.S. Supreme Court, which heard its first case about the 2024 election. You're looking at some of the footage and some of the protesters who were there this morning. If Trump's conduct or alleged engagement in an insurrection bars him from the ballot, as Colorado has decided, that was the question before the court. The justices at times considered implications of the violent attack that occurred, remember, just across the street at the Capitol, bringing home in a very physical sense how the high court operates in tandem with the other branch. The justices referred to that attack at times, but careful to avoid prejudging the other prosecutions from that day. They focused on this question of if a state can respond to that attack by deeming a politician an insurrectionist and then booting him off the ballot. Everyone realizing today the stakes are high.
Monumental day in judicial history.
Donald Trump is now at the center of a U.S. Supreme Court battle.
A legal case that could rock the race for the White House.
Voters in Colorado sued, aiming to remove Trump from the ballot.
The Supreme Court facing a major test.
All 9 of them seem to be looking for a way out of this.
It seemed like there were at least 7 votes against Colorado.
This is very personal to me. I've gone through a lot of presidents, and this is the first one that is trying to destroy the Constitution.
This is a grave day for democracy.
There is strong evidence against Donald Trump for those plots to overthrow the election. But today's case was always going to be an uphill battle for Colorado's Trump ban, as we have reported on this very program, because Colorado's move tries to step into a legal space traditionally reserved for other actors, a point that many justices raised in their skeptical questions today, including, we should mention, justices appointed by Obama, Biden, as well as Trump. Now, I was in Washington this morning to watch from inside the courtroom, and the justices were read in on the case, the briefs and history. It was clear this was a big one, not some random technical item. And some of the toughest questions were as much about practical realities as any arcane law. Take Chief Justice Roberts, a Republican appointee who prizes independence for the court. He set the tone by asking about a glaring problem if Colorado were to win today and any state could then boot candidates. Basically asking, then wouldn't that set off a kind of political arms race for the whole election year?
I would expect that, a goodly number of states will say, whoever the Democratic candidate is, you're off the ballot, and others, for the Republican candidate, you're off the ballot, and it'll come down to just a handful of states that are going to decide the presidential election. That's a pretty daunting consequence.
The lawyer for the Trump ballot ban was left denying that premise, arguing that this insurrection was so clearly documented, extreme, and factually unique that any copycat efforts to disqualify other innocent candidates for a made-up insurrection would obviously be worthless or frivolous. Now listen to this exchange, with Roberts interjecting to note that in politics and law, the lines matter precisely because one person's frivolous attack could be another person's strongly held political holy war.
The fact that there are potential frivolous applications of a constitutional provision isn't a reason.
Well, no, hold on. I mean, you might think they're frivolous, but probably the people who are bringing them may not think they're frivolous. Insurrection is a broad term.
We haven't seen anything like January 6th since Reconstruction. Insurrection against the Constitution is something extraordinary.
It seems to me you're avoiding the question.
There were several moments like that today with the justices who are steeped in the nature of government conflict, of how things become lawsuits and how lawsuits become appeals and how appeals get to the high court. These justices noting that the defenders of the Trump ballot ban are demanding sweeping powers for one state. And legally, if the high court were to make this the precedent or the rule, then that power would, of course, be wielded by all the other states. So that's a legal point about uniform rules. It's not some automatically pro-Trump point. And Obama appointee Elena Kagan put it crisply.
I think that the question that you have to confront is why a single state should decide who gets to be president of the United States.
As they say in Supreme Court jurisprudence, ta-da. That was very crisp. And you could see she was putting it not just as a question, but as a criticism or a concern. It was one of several the court had, but may have sparked the most audible unity on the bench was this practical thing, because justices know any future clashes over a state booting a candidate would probably come back up to them, and maybe on tight deadlines. in a system where the presidential race uses the National Electoral College, which can turn on a few or even just one state. Now, we put together just a sampling of today's arguments where the justices across appointments from both parties voiced that skepticism. And if you listen to anything tonight, listen to this, because you're going to hear the key parts from the rulings, kind of genesis today, the oral arguments, where it almost sounds like the justices are announcing that they would oppose a ruling that hands this power or chaos to every single state's potentially differing definition of whether a candidate is deemed an insurrectionist, a traitor, or otherwise suddenly deemed ineligible to run.
Suppose that the outcome of an election for president comes down to the vote of a single state.
One state's decision to take a candidate off the ballot affects everybody else's rights.
Really, it's going to have, as Justice Kagan said, the effect of Colorado deciding.
If what Colorado did here is sustained, other states are going to retaliate.
You can hear it just all the way down the line, that concern. Now, the best substantive rebuttal would be to argue that Trump faces more evidence than just some allegation that some state might make about a random candidate. But in law, even that statement I just made to you, bad evidence on Trump, that doesn't resolve the legal question of who gets the last word on that evidence. Is it some partisan election official? Is it a few state judges? Is it the Supreme Court? And it coming back to them all year if other states do this? And if it is the Supreme Court, all right, then what's the evidentiary standard they use to deem someone an insurrectionist? Is it the high criminal standard that we associate with criminal law? Is it a lower standard because this is a ballot access issue? Do they have to hold their own factual trial, or do they take, with some deference, the positions and findings of these lower states? And what if these lower states use different standards of evidence? Everything I'm just saying here are some of the types of questions that the justices served up to Colorado's lawyer, who, by the end of oral argument, was practically pelted. These are not questions that have clear examples and answers from the lower proceeding in Colorado. That state basically held a fast proceeding. It deemed Trump an insurrectionist. It said that the Constitution thus boots him from the ballot. But remember, that goes even farther than Jack Smith charged in the case that hasn't gone to trial yet. Now, at one point, the lawyer was facing a kind of a tag teaming between Biden appointee, Justice Jackson, and the controversial Trump appointee, Kavanaugh. Not because the two of them agree on much about justice or voting rights, but because that illustrates how unusual and perhaps legally unsupported the Colorado position is. And I can tell you, in court today, in the room, you could kind of see Jackson and Kavanaugh calmly bouncing off each other's intellectual lines of inquiry, that they did seem to share the same premise for their questions. I'm going to show you just a quick part of that. Jackson citing the text of the 14th Amendment and basically questioning that if it is vague, let's say it's vague, wouldn't then the best thing be to err on the side of allowing more candidates to run or more democracy? And in doing that, you'll hear him first. She went on to cite her Trump-appointed colleague.
What about the idea that we should think about democracy, think about the right of the people to elect candidates of their choice, of letting the people decide?
If there's an ambiguity, why would we construe it to, as Justice Kavanaugh pointed out, against democracy?
Why, she's asking. So you take that today. What did we learn? This court, with these members, is widely skeptical of using the power of state ballot bans to litigate or punish candidates for January 6th conduct. Now, does that mean that all the justices are soft on insurrection or pro-Trump? Of course not. If you just put the legalese aside, what the court is skeptical of is using the ballot ban as the punishment here. Just like someone could oppose using the death penalty as punishment for robbing a bank. They oppose that remedy, death for bank robbery, but they can also oppose the bank robbery. If that sounds simple, that part of the case is that simple, because at its core, the Trump ballot ban, as we've reported, was a new and unusual and obviously pretty extreme remedy for this situation. Now, if you're a total partisan, today's arguments may have been hard to hear if you felt like, gosh, if Trump's a 50-50 issue or 55-45, whatever you want to call it, why is everyone doing something that sounded very skeptical of the thing to hold Trump somehow accountable? But I'm telling you, it's more than that, or at least it's supposed to be more than that at the High Court. If you believe the court can, at least on its best day, be more than just a partisan clash with different, more boring language to get the partisan ends done, that it might truly tackle law over politics, then today was actually kind of encouraging, at least in the tenor and the questions. But don't get me wrong, there are still hard questions left in and beyond this case. Will this High Court evince the same discipline and fairness when it gets, if it gets, this other case? Will it let the DOJ proceed with the actual prosecution of criminal defendant Trump for January 6th? Does this court know that the ruling may ultimately advance a candidate who poses a documented risk to the very voting rights and the democracy that was discussed so much today at a higher altitude? Now, our reporting tonight on what happened today has tried to be factual and fair about the arguments. That same standard requires asking some other factual and fair questions, like, does this court understand the fact that candidate Trump is campaigning on a defense, not a denial, but a defense and an embrace of his past plots to overthrow the voters' will and our democracy, that there is nothing normal or democratic about his stated campaign? Those are big questions. Supreme Court arguments are made of questions. And asking the right questions can help determine the right answers, as well as potentially the future of our republic. As someone else steeped in the law once put it, I'll answer all your questions, but then y'all got to go. Now, the question I ask for you is, how bad you want to know? Democracy is under threat, even as Colorado's remedy struggled for legal and historical reasons. How bad do people want to really know the answers to the biggest questions of all as we barrel towards a potential campaign with only one candidate on the record supporting a democracy that was discussed so much in court today? The Supreme Court heard this ballot ban case over whether the insurrection is a reason to bar Trump from actually being able to be on ballots this November. It took place across the street at the Capitol, literally right across the street from the Supreme Court, which is a juxtaposition that we've discussed about this entire event, physically and symbolically. It's a building where a measure of justice is being sought for what occurred across the street. And it was notable during the oral arguments, Trump's lawyer actually had to acknowledge some of that. And while there are debates about what to call the insurrection, the lawyer went far, far further than his client, Donald Trump, in admitting the shameful, violent, criminal conduct of the Trump fans that day. This is new from today. Take a listen.
This was a riot. It was not an insurrection. The events were shameful, criminal, violent, all of those things, but it did not qualify as insurrection, as that term is used in Section 3.
You can hear that the lawyer was trying to draw a distinction for legal purposes, but that is a Trump lawyer now in 2024, in a time where there has been tremendous propaganda and lies trying to minimize what happened that day, because even conservatives, Republicans, and many independents are horrified by it. So they've tried to lie it out of existence. So this is new, and this is something that may cause friction on the Trump legal team with the client, but it's a Trump lawyer saying this was a shameful, criminal, violent act. And of course, everyone knows it related to what Trump, his client, discussed. Now, we've laid out the stakes for American democracy here tonight and the rule of law. Take a listen to this point.
The reason we're here is that President Trump tried to disenfranchise 80 million Americans who voted against him, and the Constitution doesn't require that he be given another chance.
That is the Colorado side. We talked about some of the problems they face, but you can hear the argument there that there is something bigger going on than just the legal debate over which state or which officer will decide this, that rather you got to deal with what happened on the 6th. You got to deal with it now. Now, Brett Kavanaugh, a Trump appointee, brought up what he views as a potential flaw, or at least a question, for the anti-Trump position here, arguing that, remember, whatever might come, Donald Trump could be convicted in more than one case. Donald Trump, as a legal matter, might end up incarcerated. But Kavanaugh noted he hasn't been charged with the federal crime of insurrection.
It's a federal criminal statute, and if you're convicted of that, you are, it says, shall be disqualified from holding any office. And so there is a federal statute on the books, but President Trump has not been charged with that.
Fact check, true. That was a point in court. And if you watch this program, we actually raised this with one of the plaintiffs, the Colorado elections official, the Secretary of State, because, as Kavanaugh just repeated, if you were actually convicted of insurrection, you wouldn't have any cases like this. You wouldn't have a question about which case decided it. A jury of your peers in the system would have convicted you, and you could not be on any ballot. Now, Trump faces over 90 counts in 4 cases. Colorado's lawyer stressing the unprecedented nature of this is that basically the court and the country should care more about all of that pile of evidence and the facts on the table, care more about that than what Colorado argued were legalistic concerns.
There's a reason Section 3 has been dormant for 150 years, and it's because we haven't seen anything like January 6th since Reconstruction. Insurrection against the Constitution is something extraordinary.
If you want to put it in a nutshell, many of the justices seem to be saying to Colorado through their lawyer, hey, what you're doing is unusual and extreme. And at bottom, one of the lawyer's better arguments, which may not have carried the day, but one of the better substantive arguments was, yeah, what Trump and his fans did was unusual and extreme. And this is the time to deal with it.